Alexandre Pacheco da Silva. I'm a law professor here at FGV São Paulo Law School, and I'm here with Professor Vera Rusinova from Russia, and she's actually here with us conducting a course regarding international law in a new cyber reality. And one of the things that I would like to start asking Professor Vera Rusinova is, what is the meaning of this concept of new cyber reality? We usually discuss a lot of topics regarding the impact of new technologies, not only in our country, but in the international level. And one of the things is, are we living in a different world if we are comparing with our past? And I would like to actually thank you for being here and thank you for accepting this interview, Professor. I think we will have a lot of good conversations, a lot of good discussions here at this interview. Thank you.
Thank you, Alejandro. So let me start with many thanks to your university, to this program, as it's really an honor for me to be here and represent my university, the High School of Economics here in São Paulo. I have started my course saying, students, that probably this is a piece of irony that the Russian professor is going to tell you about public international law and its applicability and problems concerning its application in a new cyber reality. As you know, many cyber attacks that occur nowadays sometimes are allegedly attributed to my country. So therefore, it is really an interesting stuff to discuss the problems concerning new cyber reality. Also being here in Brazil, as Brazil is also one of the countries which seem to be very developed in the terms of IT technologies. So I think that these topics are very relevant for all the countries, especially for our two states. When I'm speaking about new cyber reality, I think, and it's you know, I'm an public international law professor. Definitely, the relationships between states has been significantly changed during last decade, let's say, because just thinking about the very first cyber operations which could have been qualified as having occurred at the interstate level, we can probably start with the number of cyber attacks which occurred during the so-called Kosovo intervention or Kosovo military operation. But these cyber attacks are probably not the most famous ones. And then was a cyber operation which was called a Titan Rain, which occurred or has been committed against a number of websites of the main governmental authorities in the US and UK. And these cyber operations lasted for a number of years. But then probably the most famous one happened in 2007, and it was a cyber operation, a cyber attack committed against a number of different internet sites, networks in Estonia. And this cyber attack actually has been connected with the situation concerning so-called bronze soldier statue in the center of Tallinn. And the story was that it was a decision of the municipality of Tallinn, the capital of Estonia, to remove this monument, which symbolized for the Russian side a great victory in the Second World War, but symbolizes something else, something different for a number of Estonians. In particular, they connect this particular statue and monument with the invasion of the Soviet forces to Estonia. So thus it was a huge controversy and a cyber attack which occurred, and definitely the results and consequences of this attack were huge. This triggered discussions and negotiations at the international level. And definitely what became very important, crucial, was the question, first of all, whether and then how public international law is applicable or can give answers to such kind of attacks, which definitely can occur all around the world. And then what happened next was the creation of the NATO Center of Excellence and the beginning of the work on the Tallinn manual. So nowadays we know that we have two versions of the Tallinn manuals on application of international law to cyber operations. And this is how it started. So definitely we can, from this perspective, we can qualify this kind of cyber operations against or informational infrastructure of other states as a new phenomenon, something new. As previously, we are not as dependent on IT technologies, IT means, on computers, on networks, on internet. And nowadays, so I'm always telling, this informational technologies are very important to fly to space, but they're also important if you are bored and would like to speak to your refrigerator. So therefore, we are surrounded by the IT technologies, they're everywhere. And speaking about interstate relations, what we witness now is a very tricky situation when the states which are, let's say, more developed in the sense of IT technologies are at the same time more vulnerable in respect of possible operations, attacks, and so on. So those who we can tell are more equipped to sponsor, to organize such kind of interventions, at the same time as those states which can be regarded as potential victims or main targets for such kind of attacks. So this is a kind of combination of two sides of the coin at the same time. But indeed, this fact makes the questions concerning applicability of public international law and interpretation of existing rules very controversial, as, in my opinion, this double position of the, let's say, major players at the scene leads to the result that states are very often reluctant in respect of admitting that, well, existing international law, so lex lata, treaties, customer rules that we have, or principles that we have, are directly applicable, and the only stuff is to interpret a little bit and or use analogy. This is not like that, and I think that the major picture of international legal scholarship on this issue, so on issue of applicability of international law to cyber operations, can be represented as constituting two extremes and oscillating between these two extremes. So the one extreme would be to tell, well, this cyber reality is here, but all the cyber operations, they have really physical implications in the real world which has been already regulated by international law, so field, space, sea, and so on. But on the other side of the spectrum, we have another attitude which sometimes is even officially shown by the states, by the governmental officials, which means this is really something new, and you cannot just go and directly use analogy with all existing and known kind of weapons, operations, types of force which can be used. So what we need is to acknowledge existence of a new domain, like cyber domain or cyberspace, and also what we need is a new regulation. So this point of view can be qualified as a very interventionist one, so we should wait for a new law. And the problem is that, well, probably for the states nowadays, it's much more comfortable from many points to sit and wait, to witness what is going on, not to express their position very directly, and then also gain profit from these ambiguities that surround, that foggy atmosphere that surrounds application of international law to cyber operations. So, thus, speaking about this new cyber reality, definitely trying to keep as neutral position as one can, we can probably say that indeed, in some elements of cyber operations can be characterized or qualified as having these already known implications in the physical world, and probably we can compare. But on the other side, there are a number of features and elements of that kind of operations which do not. For instance, all these types of cyber attacks which lead to the loss of functionality, for instance, denial of services, and so on. So the question is, should we use a military paradigm of public international law and push directly with use ad bellum rules, or should we switch to the level of sovereignty, non-intervention into domestic affairs, and discuss applicability of these norms and principles to the cyber operations. And even here, we would definitely discover that existing lex lata norms with their accompanying interpretation given by the ICJ or whatever courts is not enough to describe this new reality. And thus, I think that it is a combination of questions, and indeed an answer to the question of whether existing international law is applicable to this new reality or not cannot be as straightforward as many of us would probably dreaming of.
And another question that I have for you, Professor, it is, you mentioned when we were speaking before the discussion that actually you handle regarding mass surveillance. One of the things that we actually discuss a lot in the matter of privacy is there a dilemma between security and privacy? Is there a role for the international law to intervene on behalf of citizens that, in the terms of human rights, are actually being mass surveillance? And another thing that is very important is how can we address the mass surveillance in the national level comparing with the mass surveillance in the international level? Because you have a lot of accusations that country, not only the US, but other countries that are actually using tools to monitor, to try to track citizens that are citizens of interest for them. And one of the things is it possible for a developing country actually try to fight against this kind of situation? Are we living in a permanent cyber war reality? Because when you mention a new cyber reality, it seems that the dominance of new tech tools would be compared with the dominance of a nuclear bomb in the past. So do you consider that this new scenario could actually address the question between how can we address the security issues in the international level, and how can we protect at least the last part of privacy that we have in our hands?
So thank you very much for this question. It's a great issue in public international law. And to be honest, should we compare legal scholarship with, for instance, scholarships or writings of, for instance, scholars dealing with social studies, you would see that there's a huge difference in perspectives and in evaluation of, for instance, international human rights law as an instrument which would be still able to protect privacy of individuals. As for instance, the sociologists, they claim that they even pronounce and articulate the death of international human rights possibility to address these issues, claiming that it's outdated, it's totally not working, it's not effective, and the impact is as much as zero. On the other side, so us international lawyers still having this very strong incentive in trying to prove that still international law is relevant and international human rights law is relevant. We are also definitely we are challenged by a number of questions which arise. And should I classify a number of the threats that we witness, that we encounter with, I would say that there are three main threats. So the first threat is definitely this security issue, or security trump, I would say, as whenever it is a security used by whatever government, it seems like it overwhelms whatever arguments, claims based on, so let us protect a particular individual, how it is important to have private life, or at least something from the private sphere that we have ever had. So this is the first issue. The second danger, the second threat that I would identify, I call it by my own as a consensus of big brothers, because it seems that so when we would evaluate national approaches, national legislation, it seems like that state by state, they have started to introduce and launch mass surveillance programs of different kinds and types in their own countries. And it seems like it is nowadays even a consensus of states, of governments, that it should be done. And it's really strange if your government is still not in this team. And this indeed lead us to a new, once again, new normal. So to be to undertake this program, to launch this program, this is something really normal. It's new normal in Europe at least, and many other continents as far as I'm concerned. So therefore, this is definitely a threat that for public international level as well as on many occasions, and there are many ways how domestic law, domestic approaches influence the interpretation of rather general rules that we have at the international level. So it's also important, and please do not let us forget for whom and by whom public international law was created. And the third threat that we can identify in this field, which is really very dangerous for international human rights law, is a sociological phenomenon which can be called as to be watched. Is becoming a new social norm. So it became also like normal in social relations, in inter-individual relationships, that you are like almost all the time watched, even if you think that you're sitting at home and everything is switched off except your mobile phone. It is clear now that even analysis of the metadata can help anybody to understand who is sitting next to you, who is sleeping with you, who accompanies you for whatever restaurant or what you're buying for your lunch. So therefore, nowadays it seems like to be really a new social reality, and it also has implications for the legal norms indeed. So thus the question is, so how international human rights law would meet these threats and these challenges. And nowadays what we have, at least in Europe, is a number of judgments rendered by the European Court on Human Rights on the issue of mass surveillance. And the two famous cases recently decided by this court are Centrum for Rättvisa versus Sweden and the Big Brother's Watch and others versus the United Kingdom. And in these cases, both of which were decided a year ago, the International Court of the European Court of Human Rights, came to the conclusion that, in general, it is up for the states, for the governments, to decide whether to launch a mass surveillance program or not. So, mass surveillance per se is not illegal under the European Convention on Protection of Human Rights and Fundamental Freedoms. So, I think. First of all, we should definitely wait for the decision of the Grand Chamber, as both cases were rendered for the Grand Chamber. But nonetheless, I think that as international lawyers, we should not just take aside and sit and wait until the states would elaborate and develop their mass surveillance programs further. And I think it's also our task to think on how and by which resources the international human rights law in the first line can address these issues. And I think, and in my research, I try to develop a number of ways how existing norms, how existing institutions, by use of internal and external resources, can still give adequate answers to these problems.
It's a very interesting thought, in a very interesting answer, because one of the things that we discuss a lot here in Brazil is, do you consider that the international law and the international law practitioners are fully equipped to deal with those challenges? Because one critic that we actually try to address here in Brazil, it's, oh, international law is too slow. and it is too slow because you need to negotiate a lot. You need to coordinate countries that not always agree upon some values, some legal concepts. They are trying to fight back. We have the political issues regarding those topics. And when we start to negotiate, we have another government that we needed to start from the scratch sometimes. And one of the things is, can we actually trust international law to deal with the pace of new technology, the impacts of new technologies, not only in cyber attacks, but in this new cyber reality? Because that's one of the things that we needed to address, because here we have a lot of practitioners that will answer, no, I think international law is not the proper field to deal with those topics. What do you think about that?
I think that indeed an answer to this question can be multi-layer, as we have different fields, different subjects, and sometimes we do have a number of norms which are probably general enough to be applicable to a new phenomenon. Sometimes what is needed is probably another perspective to existing norms, and sometimes what we do have is a kind of gap, whether we should wait for a treaty or for a new customary law which should crystallize step by step. Here once again, what is important, I think, is that although indeed all institutions, international institutions, courts, quasi-judicial bodies which apply public international law, they have their own structures, biases, and so on. But speaking about national level of application of international law as well, everybody, we have our preferences, obligations, influences, and so on. But what is important is to still to believe that public international law is not as positivistic as we sometimes think about it. So this values layer of public international law, I think, might be once again revisited, reevaluated, or we should recall that once again we are existing not in a vacuum, in something really artificial, and where all these values are something external for the system. So I think that that issue might be really important. We're addressing new questions, so we are not acting in a vacuum in this sense. On the other hand, speaking about this, attitude of and trust or distrust to public international law, and understanding of how long would it take for states to negotiate, and once again, if something would be adopted, it doesn't really mean that your state would participate and would join, or that your state would not withdraw after all. But in a number of fields which are relevant in these cyber discussions, what we witness now is the new, or probably relatively new phenomenon, which can be called as elaboration or development of informal rules. So hostile international lawyers, conventional international lawyers, we might be very uncomfortable with this situation when there is neither treaty nor a custom, but something really very soft, or probably not as soft, but occurring at the hybrid level. So when it is not only states but also non-state actors which are involved in lawmaking, or indeed when something is occurring at the experts level or private sector level, and there are not states but them, so business structures and whatever non-governmental players or actors which are articulating rules of the game. But then this is a new position, and should we say that, well, this is contrary to the rule of law? This is against all our expectations of how international law should regulate something, some substance. Now, on the other hand, this is also a kind of rule-based game, but these rules are rather more informal. And then I think that cyber reality is one of the bright examples how this informality is streaming to what was previously understood as conventional picture of public international law and international legal regulation. and you might be comfortable or uncomfortable with these types of not law but governance, probably not legal norms but more informal rules, standards, and so on. But indeed, they will be developed, and we are witnessing already in a number of different corners that these rules are elaborated, are developed, and introduced step by step. But we'll see. And it's not excluded that also these rules would give rise to new customs. Well, this is also not a very quick process, but at least that is how it's going on, and we should not be really idealistic in this respect or require a kind of new treaty or a new convention. As even speaking about a new convention, for instance, in respect of cyber operations, you might be well aware that a number of initiatives, lawmaking initiatives, which are made visible at the international level, they were met with a huge level of skepticism and critiques, as would you really be happy with a convention regulating informational security? And if states would negotiate about the rules of the game concerning, for instance, attacks on cyber infrastructure or critical infrastructure, would that be probably used vice versa as protection of sovereignty, covering also issues like human rights protection and so on and so forth? So here we can even think on all these treaty approaches as a double edges. So equipment which can be used in both directions, let's say. And our belief, our strong incentive to have something hard in respect of public international law can probably be qualified not as something which is absolutely correct or justified. So we should be careful in this respect, I think.
So, Professor, thank you very much for the interview, and I hope you have a great course ahead of you. Thank you.
I'm looking forward. Thank you, Alexandre.